for higher GC news. Mima Ubia Aquaba had the latest hot Aremeyaw Bremo. And Zonia subscribe to channel idea, but more than say over subscribe. The way say over click a year the subscribe button. Now wabele notification. We have video for free be upload with the first person once ever can a year video. I feel we are now like video give us a thumbs up now share my work for so now when you be here. Now who and somewhere ekoso ewo Ghana memo hanum afintente mara yembura ye somewhere abeto ye pnoso uminti ye sankomo ya babeto je sa report mama yiti sansem ye ekoso uminti.
It's one that also should get the attention of the General Legal Council. We'll see how the coming days will be, but people, I recall a year ago for your position on this matter, you had indicated consistently that at the time he should have resigned, but he stayed on. And in fact, this year, February this year, he addressed a press conference and gave some detail as to why he did what he did, and essentially making the case that that conversation, which was recorded by Richard Jackman, was the only conversation he had with him during the trial. And essentially, that advice to Jackman to obtain a medical report was not born out of ill intent, but rather a genuine suggestion in light of Jackman's health condition and his own tight schedule due to an international case he was handling at the time. Does that suffice?
At all. It doesn't cut master. It doesn't. It was just a ruse. You know, as a society, we were very clear at the time that, look, the Attorney General had breached the rules of ethics, all right? And his statements in the tape just sought to destroy the justice system. Yeah, that much, it was clear. And let's be very clear about this. Look, it doesn't even matter the outcome of the General Legal Council, okay, investigations to this matter, right? The fact remains that as citizens, we all heard what Godfred Dame stated in that tape. And those statements are unethical. Yes, the General Legal Council can give a different opinion on it. They can say, look, they don't find it unethical. That doesn't mean that as citizens, we cannot continue to say that is unethical. We are also allowed to pass judgment. We heard it. What we heard is not anything that should be allowed in a thriving democracy such as ours. So rest assured, I mean, you don't have to say, oh, this is the kind of case that we wait for the outcome of the General Legal Council's decision. No, this one, we also have a right to have an opinion, right? And what we heard, anybody who hears it, it was very clear. You heard Franklin say it. Godfred Dame was coaching Jackman, suborning him, telling Jackman, no, don't put it that way. Do this, do that. Godfred Dame told Jackman, go and get a fake medical certificate. This one, is it the General Legal Council that's now going to tell us that, yes, it's a fake medical certificate that Godfred Dame requested?
He said it wasn't born out of ill intent. And that, indeed, when he went, he actually obtained the adjournment because he was not well. So the fact of him asking him to obtain a medical certificate because he was not well was nothing but factual.
No.
That's his position. That's sometime in February this year.
What did Godfred... maybe play the tape again. Jackman resisted. Jackman said no. Jackman said no.
I'm only telling you what Godfred Dame said.
Spin. I'm sure you know the spin doctors. Godfred Dame would spin the matter, right?
Why do you think so?
Oh, because I have heard the tape and the rest of our fellow citizens have also heard the tape. It's clear. Very, very clear that it was Godfred Dame who suggested to Jackman that he should go get the tape, notwithstanding the hesitations and resistance by Jackman. Please, listen, we don't need to spend much time on it. It's clear. And yes, so we must, right, of course, continue to hold him accountable in the court of public opinion whilst we wait for the General Legal Council to also conduct its investigations. Because, I mean, this thing had embarrassed us. It had brought the criminal justice system so low that, you have a prosecutor go on record to do such things, and yet the system was unresponsive. They wouldn't take him on. We sat here, made a lot of noise. And then it wasn't that. Look, that kind of conduct from a lot of Supreme Court decisions, it should have even started. We made that point that it was for the trial judge to refer the matter to the General Legal Counsel. Yes, you will find a number of cases. Yes, you will find
Republic versus ex-party General Legal Counsel and Sumwa.
Yeah, there are other ones.
It indicates that the court being an arm of it, as part of the judiciary, has the legal mandate to refer matters that it comes to a conclusion that the lawyers in the matter, either the lawyer or the lawyers in the matter, have misconducted themselves, and that by that the matter could be referred to General Legal Counsel. So a judge sitting in the matter could decide on whether or not you have acted rightly or not in terms of ethics-wise, and refer you to General Legal Counsel.
But that did not happen.
Yes, other cases, the Bawumia case. In the Bawumia case, the Supreme Court referred some lawyers to the General Legal Counsel, right? Well, then there is the Kofi Atanle case. Look, the cases are many. It's a tried principle. It's even one that you don't need to cite any authority. You don't need to mention. Lawyers all understand that, hey,
you don't joke with the judge.
Once the conduct is found to appear to breach the ethics, the judge should simply pass it on to the General Legal Counsel. It's like what Jʊdge said earlier on. Godfred Dame was, untouchable. Yeah, he's the president's darling, because he would do a lot of dirty stuff for the president, right? So that was it. So he had the ear of the president. People around knew that, hey, don't touch Godfred Dame. If you touch Godfred Dame, it was tantamount to touching Akufo Addo. And, you know, as I said earlier on, a lot of the time you find public officers take decisions based on their stomachs. And I'm like, no, why would you do that? That's why, for me, I went to law school. Earlier on, as I told you, my first degree is in business. By level 300, it was clear to me that, no, I would not make a typical employee do this, and I just do it. Of course, I obey rules as a lawyer, but certain things, when a thing is not right, I basically was looking for a situation where if I feel this is not right, I will push it to the end. And so you are likely to get fired every day. So go to a profession where you don't need somebody to employ you. Once, you understand the law, you can operate on your own, of course, subject to the rules. So that is why we should stop. It was so clear that this matter had to go to the General Legal Counsel whilst we were, in the previous administration. But Charlie, people looked the other way because they didn't want to offend Akufo Addo. I see why once again, the good people of Ghana saw through it. I said, okay, now we will show you where power lies. And then we gave them a very humiliating defeat, right? So that is it. And you even remember that, look, even in that very case, the trial judge advised Godfred Dame to stay away from the case. After the tape was admitted to evidence, the trial judge said she was advising Godfred Dame to stay away from the case. Godfred Dame ignored her and kept coming to the court and kept participating in the trial. Can you imagine? You ask Jʊdge or ask Ma'am, when the trial judge tells you, cancel this case, please don't come here again. Let your colleagues in your law firm or the Attorney General's chambers conduct the case. Wow, come on, unless you are not a practitioner. Yeah. A judge, it's not even a subtle cue, not one that maybe you say the language is not clear. This one, when you read the ruling, it was very clear. The judge was very clear that Godfred Dame should stay away. Godfred Dame ignored her. Okay. And that should tell you the kind of influence was.
I saw that you intervened when the issue came by saying that, Godfred said the medical report was to satisfy a particular end. That's not the case.
Well, I was
involved in that matter with my senior Dr. Bassett Ato Forson. Look, it was a very simple thing. Godfred was traveling, and for fear that Richard Jakpa will come and testify and cross-examined, he wanted Jakpa to frame up the story in a particular way that implicates Ato Forson. And so if you listen to the audio recording, the whole idea for the medical report was to delay the trial, to allow him to travel and come back and do
the cross-examination and elicit particular answers from Richard Jakpa. That is
he had a tight schedule. He had to deal with that.
So that is how witness tampering operates. Look, I've always maintained that in good conscience, Godfred Dame, if he's a Catholic, should get a Roman father and possibly do a confession and ask for forgiveness of sin.
What do you mean?
You see, you don't know the conspiracy that Godfred built to put Ato Forson in jail at all costs. It's a painful episode, and that should never happen again. Look, I don't care whether you are NDC or MPP. Look, per our rules of engagement, we are supposed to provide representation to anybody, provided it does not offend the rules. That is our calling. So it matters not.
Okay.
But where an attorney general, and that is why we say that prosecution is a public service.
Yeah.
It is different from persecution. If it is only prosecution, and the prosecutor's code of conduct is that don't do anything to secure conviction at all costs.
Yes.
Yeah.
Because you are providing a public service. Follow the ethical rules, present your case, and let the judge decide what you want. Recently, my Lord Justice Akabuafo, in a recent Court of Appeal decision, where a young man was convicted, spent some years in prison, only for the matter to come to the Court of Appeal, and it turned out that, look, there was no evidence linking the guy to the crime. But this guy had been convicted and spent. So my Lord Akabuafo took time to elaborate what prosecutors and investigators should do so that they don't put innocent people in prison. Because sometimes by the time the appeal is heard, the person would have lost everything he's worked for in life. We don't want that kind of scenario or situation again. And that is why I strongly believe, it doesn't matter who you, the Attorney General, is. If you are not following the rules, because you see, I always say this, and any time I met police officers in court, you know what I usually tell them? I say, look, in my almost 12 years of practice, I've represented a lot of police officers. So you, a police officer, tomorrow, God forbid, you can be the subject matter of criminal investigation.
Yeah.
It had happened. I've represented police officers in court. You understand? So I always tell them that, look, deal with fellow countrymen with a certain human face, so that tomorrow, if the same rules apply to you, you will not be found wanted. The same thing applies to prosecutors. Let us all be fair in our dealings with fellow countrymen. That's all that I say. As for the rest of the petition, I think I've seen Richard Jakpa. He appears not to be happy with the petition to the General Legal Council.
Why is that?
Because on his Facebook page, I saw him raise serious issues that he believes that he has his own plan for this matter, and that he believes that the petitioner is quote unquote becoming a busybody.
Oh, but this one is a civil one. It's without prejudice, even civil. It's without prejudice to any criminal action.
No, he's not even talking about. I don't know what his plans are, but if you look at his Facebook comment, you can see that he's not pleased with whoever it is that is before the General Legal Council, because it appears he himself wants to be the one to petition as far as this matter
so this
is concerned.
Is more like preempting his plans.
And I think he has some reasonable suspicion that no, it may be a sinister, so that if the matter goes either way, maybe Godfred may end up, escaping from the what is required by law, because he definitely appears not to be happy with this whole thing. Yeah.
Yeah, okay, so can say so finally, yes, so you see, it's based on these very damning statements, right? A serious indictment on the justice system that you find the decision by Chief Justice Torkonoo to engage Godfred Dame not appropriate. I mean, that one we have to be very clear.
Why is that?
A man, we've just recounted all the things, so I don't need to repeat. A man who has said all these things, a man who seeks to undermine the justice system, then a suspended Chief Justice goes to engage him. I mean, what kind of country is this?
But
is Dame the only lawyer in this country?
It's well within her right to do.
Oh, no, it's not every right.
She decided that this is the lawyer she wants.
It's not every right that you exercise. It's not every right that you exercise. Sometimes you look at the public interest and then you forgo certain rights. It's not every right. What's the thing? Those of the Bible. I think the last time I quoted the matter of 1 Corinthians 6, right? That area onwards, where they say, the Bible says, everything is permissible. Everything is permissible, but not everything is beneficial.
That's morality. That's morality.
Okay, today you can say that's morality. Why go to morality. Find out tomorrow? Yes, even granted. Why are the churches full? Because people ascribe to a certain religious code. So you haven't shut down my argument when you say it's morality. A society without morals, what would it be?
You know, when it comes to law, I mean, a legal right, it is a legal right that she exercised. And I mean, nothing can clog that right of hers.
Look, even to become a judge, he stated that you are talking about morality.
And he stated that moral turpitude. So you see,
it's not everything that's only about crime specific.
But
to be appointed
going for a lawyer is an exercise of discretion. Whether you want to go with quarters A or quarters B, irrespective of the public opinion.
But the matter of optics is key, is it not? I mean, you cannot also discount that. I mean, based on everything that has been said right now, which you also acknowledge that the General Legal Counsel has reason or should be also looking into the said conduct of Godfred Dame. You said that in your earlier submission. Based on that,
yes.
And then now he is a lawyer to none other than the suspended Chief Justice. It doesn't concern you based on the optical analysis of things, from the optics.
Yes, like I said, it is a discretion, and it still remains her choice. Now, if at a point in time she decides to terminate the legal relationship that she has with him, so be it. But to cover it up or to conjecture in the way of the optics alone will not sit well, because aside she being a learned justice, she has all the faculties to reason through why she would choose a particular person, irrespective of what a certain or let me say, irrespective of what a number of persons think of her choice. You could go for, just as a private person, you could decide to go for a particular lawyer, and one would say, but why have you gone in for this lawyer? And I mean, in my almost decade of a practice, I have seen persons who have had such rhetorics, but the question is, it's choice. Someone would want to go for a lawyer who probably drives a certain vehicle. Someone would want to go for a lawyer who sits in a trotro. At the end of the day, the person is looking at the quality of service or a certain relationship that has existed over the years. So there are myriad of decisions that goes through the mind of an individual in selecting a particular lawyer, and that cannot be discounted. It is her legitimate right to go in for anybody, including Godfred Dame, irrespective of the optics and the analysis.
So, Godfred Dame himself has been responding to this argument of he representing Gertrude Torkonoo,
Yeah.
her leadership.
Yes.
And he says that position of the optics is baseless and completely unfounded because his involvement goes beyond Justice Torkonoo as an individual, and also the fact that it's about challenging the unconstitutional manner in which he says this petition process has been handled. That's what he said. I just want to put it on.
Before my senior Martin comes in, let's look at these two scenarios. So Godfred is lawyer for Vincent Assefuah. So they first brought an application. In Relief 1, they say that Her Ladyship, the Chief Justice, was not notified prior to the President sending or consulting the Council of State. That's the claim. Now, the claim of not being notified requires personal knowledge. So once that issue came up, some of us said, on what basis did Vincent Assefuah get this privileged information that the President has not consulted Her Ladyship, the Chief Justice? So then it created an impression of some communication between the plaintiff and Her Ladyship, the Chief Justice. Not long, there was a letter now from the Chief Justice herself asking the President to furnish her a copy of the letter so she can, as it were, put in a response. So already right from the beginning, the impression has already been created by way of conduct that there's some kind of communication between lawyers for Vincent Assefuah himself, and now suspended Chief Justice. Now that matter goes in and it fails. Only for Her Ladyship, the Chief Justice, now suspended, to formally come before the courts. Now gets represented by the same lawyer for Vincent Assefuah. And like you pointed out, it's about the optics. Me, where I sit here, I will not say that food should be taken from the mouth of a colleague lawyer. No, this is what we do for living. And so now that he's back into private practice, he needs to make a living. I will not say who should be his client or who should not. But you see, we are working out the optics. Look, the head of the judiciary, right, gets represented by the immediate Attorney General. At the time when there have been serious questions about, the public, the verdict is out there in the public. That no, you have not acted between the two political parties. You have taken side. And for that matter, like Caesar's wife, you must live above reproach. You understand? Caesar's wife must not be somebody whose name is associated with anything below the, like people can gossip about or run rumor about Caesar's wife. No. So when the story came that Cleopatra had something to do with Mark Antony, it was as good as you are God. As the wife of Caesar. That is how, when you get elevated to a certain position, you cannot do what a judge can do. Me, I don't want to be a judge. So I am in my corner. You understand? Now, those who say they want to be a judge, there's a certain elevated conversation about them. So once you become Caesar's wife, there is a certain benchmark around you based on your conduct. I would have wished, and this is possibly wishful thinking. There are many, many senior lawyers in this country, right? Many, many senior lawyers. Now, if you have a situation where serious allegations of this nature, the minority in parliament have entered, the MPP itself had actually had a demonstration relative to this. Then not only that, you have a situation where the immediate attorney general is your lawyer.
Yeah.
Have you found out who is represented here before the committee? Have you found out?
Yeah, some people raised it, but I mean, we didn't get answers.
No, I mean, assuming you have my learned senior Ayiko too, being her lawyer before the committee, what would be your view?
Well, it'll be different.
Do you get it? So, I think strategically, I don't have the capacity to advise. You know, no, I don't have the capacity at all.
Yes, but you have an opinion.
But you see, there's a reason why you read that Bible, the verse.
Yeah.
The account, if you put in account, you are doing now who kwine, and yet are doing now so the factor. Do you get it? You are doing now who kwine, but and yet you now the factor. There's a reason for that profound statement in the good book. You know, her ladyship, the Chief Justice, is a lay preacher at ICGC. I want to believe that going forward, maybe some of these things will guide how this thing is approached. It's for good reason. You see, it's not an ordinary person. If you look at our governance structure, after the president, the vice, Mr. Speaker, she comes next.
Article 57.
She comes next.
Yeah, 57.
It's not. Look, the events playing out is not a joke.
Well, for the respond to the disposition of others, that look, this matter has already been politicized, even though it's a purely constitutional matter.
Who?
We have allowed the politics of things
By
to
who?
also get in there.
By who?
So I mean, the suspended Chief Justice going in for Godfred Dame is really not outside of the politics of things playing out now in this case.
Let me tell you, I know the high hopes President John Mahama had in her ladyship, the Chief Justice, becoming Chief Justice. Right. I know.
Okay.
In fact, prior to she becoming the Chief Justice, President Mahama actually said, when Eniebua was just about, that he is very confident that the new Chief Justice who will come after Eniebua will restore.
The one they were taken out of context.
No, because that statement was made when Eniebua was just about exiting.
Yes.
And she was coming in.
Yes, and they were saying that meant that JM said
in fact it was about
yes, so, but you know they took it out of context.
It was deliberately done. They don't provide when it happened. So JM was very specific that he is so confident that with her ladyship Justice Gertrude Torkonoo becoming the Chief Justice should restore, because the Afrobarometer reports and others created an impression that there was something untoward happening with the judiciary. And so JM, then opposition leader, said, look, he is confident that with her ladyship, the Chief Justice, becoming the Chief Justice, a lot will happen. Let me also state here, even at the political committee of the party, after FECNEC, one of the highest political, committee of my party, the NDC, right? When her nomination came, President Mahama indicated to the minority that there shouldn't be any opposition.
Wow. President Mahama indicated
at the political committee level that nobody should oppose her becoming Chief Justice. So if you note, unlike the Gawu, Kumsin and Co., whose appointment came to the entire floor for a vote to be taken on them, in the case of a ladyship, the NDC minority in parliament, because it was just a minority of one, and they could have unsettled everything. All they needed was to just get one person in the MPP at that time to flip, and that should have lost whatever. But you notice that when it came to her appointment, from the committee level, it was unanimous. Her approval was by bipartisan consensus. Then on the floor, it was unanimously approved. That was the confidence President Mahama personally had in this Chief Justice. That is the level of confidence he had Why? The grounds in the petition, unless President Mahama is a soothsayer or by way of clairvoyance, how was he going to see that the Chief Justice will conduct herself in that manner? I mean, how? It is just not possible that President Mahama could see into the future. Assuming that they claim that, oh, she paid a per diem or so and so for the husband, or as I speak, I've decided I don't want to bother myself with the grounds. Yeah. Assuming these are the real grounds for which reason these decisions are being taken, guess what? How could President Mahama see into the future to say that her ladyship, the Chief Justice, was going to conduct herself in a particular manner? How was that going to be possible, Alfred? And so, right from the onset, there couldn't have been any issue of politicization until the NPP, busybody, decided to drag themselves into this impeachment conversation. With the press conferences, not only that, they even went as far as organizing a demonstration. Didn't they do it?
Yeah.
Look, when I listened to Godfred Dame on one of the radio stations, makes the point that the lawyers for the petitioners are known NDC lawyers. So, wow. Wow. Yes, you can say, and without any equivocation, that my learned senior, Mr. Chachuchigata, is a proud member of my party, and he associates with that. But how in God's name do you say Tadio Sorry is an NDC member? Look, I'll tell you this. When I became, in 2008, one of the campaign promises President Mills gave was to find the killers of Issa Mobila, the Northern Regional CPP chairman. You saw the circumstance under which he died. The soldiers, his legs up, tied him up until he died. So it was one of the NDC campaign message in 2008. Well, when we came to power in 2009, President Mills then decided, may his soul rest in peace, to prosecute the people, the perpetrators of that murder. Guess who their lawyer for the accused person was? Mr. Tadio Sorry.
Yeah.
Okay.
The NDC lawyer is the one representing Mr. Sorry, and he made the point that even in Ghana at 50, at that time, my Lord Justice Kulendi was the lawyer for the Ghana at 50 people. He said he assisted them.
Yes.
And many other matters that he's done, including representing Obiamwa.
That's it.
Guess what? Because his people master was Ambrose Derry, the two of them did Malam Issa's case. Malam Issa's case. Yeah, so here is just a lawyer who, once you approach him for legal representation, he's willing and able to do. Like you pointed out.
Some will even tell you, if you know Sorry's family, they'll tell that he's more of MPP in terms of family, the family structure.
This man, what's the name? My own brother, Oliver. The things Oliver says about JM or the NDC government, sometimes I wish I can call him and say, my brother Godwin, what's happening? But that's a free-minded Ghanaian. So to suggest that the petitioners are being represented by NDC lawyers is mischievous and deliberate to poison the atmosphere. Now that it has come out that you are the lawyer for the CJ, now suspended, what's your response to that? Then you are all over the place. That, if it's so, then we are guilty by association. It cannot be. At least, let us handle these matters in good conscience. I'm surprised that Godfred says good men should rise up. Today, if good men rise up today, he will lose his license.
Yes.
On what basis?
But the tape is clear. This one, they call it no further inquiry. This type of thing.
One of the...
When you hear it...
It's not conclusive.
It's called no further inquiry. Ask the people who learned this law in America. They'll tell you this one is called no further inquiry. It's too clear. The main thing is that
if today, with respect, good men rise up, as Godfred is calling good men to rise up, you lose his license.
Yes. Absolutely.
One of the reliefs.
But I had a question, so I was going to answer. So I'll be very brief. Yeah, you pose a question to me and then
so
yes.
Because on. Yes.
So my answer, yeah, you said Godfred Dame said that. You know,
no, it says that argument of the optics is baseless, essentially,
yes.
and without merit.
So the word baseless,
and he referenced, and he references what Jʊdge talked about, that you have some of the petitioners also being represented by persons known or known affiliates of the NDC. So really, what's the point? And then also the fact that this matter has been politicized already, so he getting into it doesn't hurt the optics as it's at play already.
Okay. Yes. Okay. So even before I go on to the substantive question, please let's note the issue of when Ma'am was saying is just a moral matter. Please, Article 128, Clause 4 says that a person shall not be qualified for appointment as a justice of the Supreme Court unless he is of high moral character and proving integrity, blah, blah, blah. So the point I want citizens to note is that we've not divorced morality from the law. The two are interwoven, inextricably interwoven.
So when you hear, a judge say that what is legally right cannot be necessarily morally right and vice versa. It is not.
He has totally misconstrued me.
Okay.
No, because before we move on, just a minute.
Quickly.
The point is that qualification to the bench, moral turpitude is part.
Okay.
Now, in the exercise of one's rights, it has nothing to do with morality. It has everything to do with the legal rights exercisable. And when that person is exercising his legal rights, what does morality come in?
So you let's leave it. Me, I just wanted to show you that in the law.
Viewers watching morality in jurisprudence by Professor Austin, it has been clear. Jurisprudence has engaged and exhausted the issues about law and morality. And it has worked from John Austin, John Bentham, Jeremy Bentham, all the way to Kelson. So issues about morality, I'm very well placed in it and understand how it is interwoven and divorced in the law. But when it comes to exercise of legal rights in getting a lawyer, it has nothing to do with morality. Because when one is going on to ascending to the bench, moral turpitude is one, because as a judge or ascending to that high office, it must be ascertained whether or not you qualify for that position. So your moral issues will be part of the conversation, but not what I am saying. It's more like putting...
Okay, can I go? I think you've made a point over. I just wanted to viewers to know that, look, in our law, and it's not only in Ghana, many places across the world, there is that confluence. Yes, that point is made. As to whether you think it doesn't apply here, that's your opinion. It's fine. Okay. Yes, so now, Godfred Dame, the word baseless. Yes, that's what I want to address in a minute. I mean, in view of all the facts we've referred to so far, okay, let me recount briefly. The trial judge telling Godfred Dame, stay away from this trial. Godfred Dame ignoring her. The things Godfred Dame has said in the tape, right? Number 3, Godfred Dame adding ACP Agojo to the treason trial when he himself said there was no evidence against him. Godfred Dame covering up the second Cecilia Dapa scandal. I'm not surprised he would say that is baseless. The claims are baseless, meaning that he himself, his judgment has always been suspect. Let's repeat what I'm saying. He's saying that the charges against him are baseless. You understand? I'm saying the word.
He says that argument of
optics. That's what I'm saying. Charge. Yes, I'm calling it's called the argument of the optics. It's a charge. People are charging him that the optics look bad. And Godfred Dame is telling us that argument that the optics are bad for him is baseless. And I'm also making making the argument that for a man of his track record, and I've named all the things, right? When he says this is baseless, I'm not surprised, because from his own track record, all the things we said, his judgment has always been suspect.
There's
so
one of the
okay.
demands, the reliefs that the Chief Justice is asking for in this particular interlocutory injunction, and that's going to be
the next.
We'll deal with it. We'll deal with the details. In fact, there are about 16 of them, but there are 3 of them that we would zero in. And because I'm mindful of the time for one of our guests, one particular one, let's start from the second one. The second one, we're going to put it on the screen, right? So I said a declaration that upon a true and proper interpretation of the same articles, the right of a Chief Justice to a public hearing and all the incidents of a fair hearing may only be excluded in the interest of public morality, public safety, or public order. So again,
that's I said, many places in our constitution, morality you will find.
But this one, this third one, that a declaration that under the same article, a Chief Justice who is called upon to participate in a hearing conducted by a committee constituted under Article 1466 to inquire into the merits of a petition seeking the removal from office of the Chief Justice can waive the privilege of in-camera proceedings. Is it her right to do so? Counsel, quickly. Okay. Is it one that you support?
Yes, let's separate. Straight answer is that her waiving of her right would not automatically result in a public hearing. That's the straight answer. Because when you look at the phraseology in Article 146, I think it's clause 8, it doesn't appear that
8.
Yeah, 1468. But did I mention a different?
No.
Oh, okay. Yeah. So it doesn't appear that it's meant to protect her alone. No, let's read it. This is what it says. It says, all proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer, blah, blah, blah. Yeah, so from the way it's been phrased, it's not clear that it's only to protect the accused in a way. When I say accused, so that we can, effective communication. It's not a criminal trial, but for a lot of people.
You are using it in the loose sense.
Yeah, in the loose sense, so that we can communicate effectively. We don't gain anything by using big words when we can. Yes. I'll use accused freely here. Yes, I'll use accused freely because
this bit.
If in certain jurisdictions, so you see that even in a criminal case, they don't use the word accused. They use the word defendant, whether it's a criminal case or a civil case, right? All right. So looking at it, you can see, and I've expressed an opinion on that. I also agree that the proceedings should be telecast live.
The hearing of this 5-member committee.
Yes.
And the petition.
Yes.
You support the call that it should be telecast live.
Even
though the constitution is explicit that it should be in camera.
Yes. So right now what we are saddled with is the language of the constitution. And I don't have the last word on it. So my opinion that it should be telecast live, please, it's not, what do you call it, the meaning of the constitutional provision. It's my personal opinion. As I've told you, my reading of it, it doesn't appear that it's only meant to protect the accused person in this case, but rather it appears it's for the whole of the system. There is still, though reduced, myth around the justice system, judges, the wigs, the gowns, and generally, our society is still evolving, so we accord a lot of, extra high value to the justice system and all that. So you can see that on matters concerning judges, we want to be sure that things don't come out in a manner as would make the public lose confidence in the justice system, etc. So you see that based on this history, etc., it doesn't appear that it's only meant to protect the person who has been accused, but it's also meant to protect and especially maintain the confidence that the what do you call it, the society has in the judiciary. And it's not only the judiciary. You see that this provision 146 also applies to a number of the independent constitutional bodies. I think immediately I can remember the electoral commissioner. Yes, we are going to remove the electoral commissioner.
The auditor general, all of those.
Yes,
people,
so you see
judge,
that, yes.
All of them are subject to this.
Very good. You say it. So, and the independent constitutional bodies, there are at least about 7 of them in the constitution, right? So, you see that this provision is meant, we are looking at those days, 1992, the way our society was, we're not that much enlightened. Even today, yeah, we are still far behind, right? But at least we've made substantial progress. So in matters like that, even if you want to test how sometimes people can get angry, you remember, okay, let me not cite the example, we've moved on. But generally, you can see that this constitution was written more than 30 years ago. The society at the time was what this constitution reflected. But now we as a people, we've moved on. Yes, we've moved on. The train has left. So the constitution now has to play catch up. That much is very clear. This constitution itself has been very clear that it's no longer fit for purpose. The design, everything is no longer fit for purpose. So thank God President Mahama has set up the committee. You know, for 8 years, Akufo Addo would have none of it. You know, that's why JM would always stand tall above Akufo Addo. I'm like, come on, a lawyer, 8 years, tweak this constitution for us. No. He wanted all the power, all the trappings of power. Yes. So moving on, yes, my heart is with the call for a public broadcast, public telecast of the proceedings. But when you look at the text of the constitution, it's difficult. So maybe somebody should go to the Supreme Court, though it's difficult, you never know. You never know. Because, so I was saying something extra, that how about us looking for more innovative ways to make the argument? So number one, can Musa Dankwa conduct a poll on this matter again, so that we are looking for other arguments? If we conduct a poll and you see that over 60% of the population say we should do it live, that will add to the calls for the system to do something.
And you balance it out with that concern that you yourself underscored, that this in-camera provision was not born out of oblivion. There was a reason why.
Yes.
To, for instance, protect the identity and also the sanctity of the entire process.
Excellent. Yes.
So if that's the case, even if the public is making that demand, would the public demand surpass the intent?
It appears so.
Of the provisions of the Constitution.
Yes, it appears so.
The framers of the Constitution.
It appears so. That was the argument I made, that as a society we've moved ahead of the Constitution. Yeah. Yes, the transparency, the calls for transparency have grown louder than this constitutional provision. The society has clearly moved on. So where you have society move, and that's one other area where you see issues of morality coming in. Sometimes society advances ahead of the laws, and so the law have to be amended to be able to catch up. This is one clear case where you see society has moved on. That no, listen, and that's how come you see the petitions leaked. The petitions leaked. People have read. We will not discuss here, but people have read and have made judgment. So we should stop playing the ostrich. Rather, want to see how cross-examination can demolish the things we've read in the petitions. You see it. So that's how come there is a higher call to see the proceedings, because you're like, we've read on paper X, Y, Z. Of course, we will not mention the details. So, what kind of cross-examination is going to undo these things that we have seen in black and white? So let's do that thing. So Musa Dankwa should do a poll on this question. Number 3, we can also look at maybe demonstrations in favor of a public broadcast. Yeah, when the society makes a lot of agitations, asking for something, because justice emanates from the people in Article 125. So if people say that, look, our sense of justice today is that this thing must be made public, and after all, even the Chief Justice has also waded in, it will add. So we are adding all the arguments. Let's read briefly. It says that Article 125 Clause 1, it says, justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution. Then you see 1252 talks about this participation of citizens in the justice system. So you see the assessor system and then the jury system. So the argument I'm making is that to the extent that it appears the majority of the people think that the justice in this case requires that it should be publicly broadcast, I think we should look at it well. Then, I mean, you see, this one is called shaking the kaleidoscope. Shake it, keep shaking. You don't know what you get.
So, it for winning and someone about better. Yapon so, Mikao says, so when you subscribe to channel idea, Bobody say, over subscribe. No, I like give video, give us a thumbs up, Nafi, share my for so now. When you be here, now, and somewhere also, I will Ghana memoir. Also with me atchere wadwen afaye and some way nyina ho I will comment box in my next video.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.